Ladies and gentlemen, I am Mamta Khatri and I will be your host for the session today. Good afternoon and welcome to the WebEx session on how to obtain funding for arbitrations in India. The session will be presented by my colleagues Kishore Joshi, Ashish Kabra, Alipak Banerjee and Tom Glasgow. Please note that this session will be in listen-only mode and will last for about 60 minutes, of which first 30 to 40 minutes will be spent on panel discussion. The remaining time will be available for question and answers. Requesting all the participants to be on mute mode for the session. You can post your questions in the chat window while the panel discussion is on. The moderator will queue up the questions for the speakers accordingly. Should you need any assistance during the conference call, you can use the chat option. You may note that this conference is being recorded. I now welcome our session presenters, Kishore Joshi. Kishore heads the regulatory practice at Nishith Desai Associates and is based out of our Mumbai office. He advises clients on securities and exchange control laws. Ashish Kabra. Ashish leads international dispute resolution and investigations practice in Singapore and is based out of our Singapore office. Alipak Banerjee. Alipak is leader in the international dispute resolution and investigations practice. He primarily focuses on international arbitration and is based out of our New Delhi office. Tom Glasgow. Tom is the Chief Investment Officer for Asia of Omni Bridgeway, one of the largest litigation funders in the world. Over to you, Ashish, our moderator this afternoon.
Thank you, Mamta. Thank you for that introduction. Very warm welcome to all our participants in today's session. Just for a few housekeeping matters to start with and just reiterating those points that Mamta said earlier. We will be presenting for about 30 to 40 minutes to begin with. And during that time, as and when participants have any questions which they want to pose to us, just type them out at the chat window. We will obviously, during the presentation, we will try and go to the presentation first, and then after that, we'll try and come to each of those questions one after the other. And hopefully we can cover all the questions. So that's about that. And one more request, it's basically to everyone to keep to be only on listen-only mode and keep it on mute so that there's no disturbance while the presenters are making their presentations or while we are discussing the subject here. Now, with that said, let's dive into our today's webinar, How to Fund Arbitrations in India. Now, this is essentially around third-party funding. And just to sort of give a basic outline of the concept, which I presume most of you already know, third-party funding is essentially where a third-party investor foots the costs of a litigant for pursuing a claim, and in exchange, if the litigant is successful, takes a portion of the claim proceeds that a litigant gets from its successful claim. So that's third-party funding, and we'll be discussing that today in context of arbitrations and court litigations in India. Now, there has been a lot of debate around the legality of third-party funding, but I think time has come that we move forward from that debate. It is now well settled, and it has been for a while, that third-party funding is permitted in India. So today we will not be discussing the typical questions around champerty and maintenance. Rather, we will start with the understanding that yes, third-party funding is accepted and legal in India. Rather, we will dive into more practical and sort of nuanced issues around third-party funding and sort of help people understand and see how they can achieve their goals and get funding in relation to their claims. So we'll be discussing areas such as nuances of a funding agreement. We will include a case study. We will discuss regulatory issues around third-party funding. And we will also try and see if people can raise a working capital, monetizing these claims, and otherwise use these claims as a source of raising capital for their needs. With that said, let me now begin with our session today and bring in one of our first panelists, Alipak. Alipak, can you just sort of outline with us what are the benefits of using third-party funding for the people out there, and what could they look to gain by actually going and resorting and looking at third-party funding as an option?
Thank you for that, Ashish. I think first let's look at the advantages of obtaining funding. And then maybe after that, I'll broadly touch upon what is covered, what can be covered in a funding arrangement. Now, obviously, in the present context, I think this is very relevant where companies are undergoing liquidity crunch. Third-party funding can be a very good option to fund litigations and arbitrations. So, to a large extent, when there's a necessity or there's a liquidity constraint, funding brings in that support to drive through the arbitration process. Next would be budgetary constraint. While companies may have funds, but they may not be looking at deploying these funds to fund their litigation or arbitration. So at that point in time, funding of cases becomes very important. We have also seen portfolio funding, so on and so forth, where a large claims which are of similar nature gets funded by funders. Maybe during the session, Tom will throw some light on that as well. Third is validation of claims. Now, third-party funding involves a detailed scrutiny of the case. It would involve 3 or 4 different layers of scrutiny, and broadly about maybe 1 in 30 or 40 cases, they receive funding. So once a case is funded, it gives a very positive outlook, and experience suggests that many funded cases actually reach settlement during the course of the proceedings, because the counterparty, sometimes even the arbitrary tribunal, if it is disclosed, when they get to know that the case has been funded, it creates a psychological advantage because independent set of people have looked at the documents and they have opined on such pieces. And that was the basis of funding. What does funding cover? Broadly, all reasonable costs. And I can briefly touch upon a few nuances. Legal fees that would include the cost of the solicitors, the law firms, barristers, Queen's Counsel, all disbursements that could be fees paid to the arbitral institutions, the fee of the arbitrators, all out-of-pocket expenses, security for cost. If in a given situation the tribunal directs a party to deposit certain amount of cost, even that can get covered in a funding arrangement. If there's an adverse cost order, if, for example, a party moves an application before a tribunal and they are unsuccessful in international arbitration, at least 85 to 90% of the cost is granted in favor of the opponent. Even that kind of cost arrangement is also included in the funding arrangement. And then there are ancillary proceedings as well, such as recourse to court proceedings for interim relief, maybe enforcement proceedings at the end of the case. These are commercial considerations which a funder and the party seeking the funding, they discuss, and these get recorded in the form of a funding agreement. And that's how things are taken forward. Now with that, I would like to stop here. Maybe I'll briefly touch upon the nuances of the funding agreement maybe in some time.
Sure. Thank you, Alipak. Probably another advantage that I potentially see of a funding arrangement is that funders consist of professionals who have previously been lawyers at various reputed law firms and other places. So having the funder also have a sort of a stake in the claim implies that even the funder is also trying to take care that the claim proceeds in a diligent manner. So usual commercial people may not be best sort of suited to understand how or appreciate how a case is progressing or not progressing. So having a funder on your side could potentially help with that as well and reduce the time and resources that your company or your company's personnel are spending to try and ensure that a case is diligently prosecuted. Having funder on board could obviously ease that burden upon the company and its employees and other people who are there concerned with that case. So that's probably another advantage that I see. But yes, having considered these advantages that you explained now, I'll probably move to Tom to sort of get a more practical outlook. And Tom, probably I'm just going to ask you this because you are coming from the funder's side. I'm just going to give you a factual problem and we just want to understand from you, how would you sort of approach this fact situation to analyze whether and how a party will get funding or not get funding, or what would be the steps involved in getting that funding. So let's conceptualize a factual problem such as this. let's say there is a construction engineering company in India, which is obviously having multiple projects, and out of some of those projects, cases have arisen, and those cases are being pursued in India and outside India. Now, amongst these set of cases, there is one case in India where an arbitration award has been obtained for, let's say, about 50 crores, INR 50 crores, or INR 500 million. And there is another case, which is a Singapore-seated SIAC arbitration, where a claim is being currently pursued in that arbitration. And let's say the claim value is INR 100 crores, or about 1 billion. So how would you as a funder try and approach this set of sort of a construct to see whether a funding can be given or not given, or what are the factors that you would see?
Thanks, Ashish. Hello, everybody. That example you've given is a good one. And really because it is a common one that we see, and the infrastructure sector across the region and in India specifically is a common source of inquiries for us. And often those businesses have more than one claim and an award. And so we're often looking at packages of claims and awards like this one. So that's a good example. Just treating them as individual claims at this stage, and to go over our process and how we would review them. We would start with a confidentiality agreement. That's how we begin all of our discussions with our client. Our due diligence process is very detailed, and we do need to see confidential documents, privileged documents in that process. And so it's important from the outset that we're documenting our common interest with the client and protecting privilege and confidentiality. So that's step number one. And then we would dive into our due diligence. And we're looking for essentially three key elements in our due diligence. The first is that we are looking at good claims. So for your Singapore arbitration, which is an ongoing claim, we would need to satisfy ourselves that the client's going to be successful in that claim, that they're going to be able to obtain an award in their favour and deal with any defences or counterclaims that might be raised by the respondent. In relation to the award in India, we'd want to satisfy ourselves that that award can be enforced, that if there's any challenge or set-aside application or appeal of that award, that we have good arguments to deal with that and maintain the strength of the award for enforcement. I should say in the infrastructure sector and the construction cases that we see, this is often quite a difficult part of our assessment. So these can be complicated claims, they can be very fact heavy, they can be technical in nature. So it can be a difficult exercise to go through to reach a really educated view on whether or not a claim is going to be successful in that sector. The second thing we look for is the economics of the project and the funding that's proposed. We need to be able to run cases at a proportionate cost to the likely recoveries. And what we typically look for is a 10-to-1 ratio between the size of the claim or the amounts that's likely to be recovered and the costs of getting there. So if your claim is worth $1 million or $10 million, it needs to cost less than $1 million to get to a recovery. And that's important because at the end of the day, once the lawyers and experts and everyone have been paid, once we have taken a funding fee commission on our investment, we want to make sure that the bulk of recoveries is still left there for the client. The final thing that is important, the third element, is recovery. And we need to ensure that once we obtain an award, we're then able to go off and actually recover from the respondent. So that means investigating the respondent's ability to pay. In the case of the Singapore arbitration here, you've probably got a foreign respondent. We would need to look at the jurisdiction where their assets are and the process for going and enforcing our award there. So those are the three things that we look for in our due diligence. If that all stacks up, we would seek to agree commercial funding terms with the client, and then we would present that investment opportunity to our investment committee. And if they also agree that it is a good investment, we would proceed to enter into a funding agreement. That's the process. But looking at this specific situation, there are some different structures that might be available. In relation to the claim, we're likely to look at funding just the costs of that claim to get it to an award phase and then enforce that award. But in respect of the award, we might look at possibly purchasing the award or monetizing it in some way by giving an advance on the award value to the client. And then we would also assist in recovering that award. We could also look at packaging the two together and creating a portfolio. And that's something we're increasingly doing and looking at in India in particular. We can package together 2 or more claims, and often it is more than that. And that, from a funding perspective, allows us to diversify our risk across a number of different claims or awards. In this situation, it might mean that we're able to place more emphasis on the award as collateral for our investment, and therefore we might be able to get more comfortable with the claim, which, given it's an infrastructure claim, might be quite difficult to assess given the technical issues that I mentioned earlier. And essentially, from the client's perspective, that then allows them to get funding for more claims than if we just did it on a case-by-case basis. So that's the process, and that's some of the options that might be available in that scenario.
Sure. So just taking this a bit forward, and I think at the end of the day, sort of harping more on your second point of the economics behind these claims, and because that's always interests our clients and people around what are the numbers. So how do you normally look at the numbers? What are the returns that are there? What is the structure that you work around, or the return matrix that you sort of think of and envisage, and how does it typically work?
Right. So there is no one size fits all. It is flexible. But the one thing that is often consistent is that our funding is given on a non-recourse or limited recourse basis. So we are entitled to reimbursement of our investment and a return on that investment only if the case is successful. We typically share in a portion of the proceeds of the claim or the enforcement of the award. So it's a binary risk from our perspective. If the case isn't successful, we get nothing in return. If it is, then we share in the benefit with the client. Typically, if we are successful, we'll be reimbursed our investment and then entitled to a commission, which is calculated as either a percentage of the amount recovered or a multiple of what we've invested. And sometimes it's a combination of both. We might say it's the higher of a percentage or a multiple, or we might say it's a multiple plus a percentage. We do like to include a percentage-based element to the calculation because it aligns our interests with the funded client and seeking to maximize recoveries. But every case is different, and it will depend on what's appropriate. It's a risk-based assessment. We are an investment business, and like any investment class, the higher the risk, the higher the return that the investor expects. Similarly, timeframes are important. The longer you are invested, the higher you expect your return to be as well. And so the returns that we will negotiate around will reflect those risks. So typically, if there is an early settlement, we will share in a small amount of the recoveries, but if it takes 5, 6, 7 years, we'll be looking for a higher return. There are ways to reduce the cost of funding. One way is by structuring things in a portfolio, which allows us to diversify our risk, reducing our risk and therefore reducing our expectations around returns. The other way is to risk share with us by sharing in the costs. And that's a common feature of our arrangement arrangements with corporate clients these days is that we will be funding not necessarily everything, but say 50% of the costs involved, and thereby we will take a smaller share in the recoveries.
So that's a good sort of a succinct explanation of how probably the economics are working around on a claim in that sense. Thank you, Tom. And let me just go back to Alipak here. Alipak, the last thing Tom mentioned is if they get the approval from the IC, they then go ahead and negotiate and execute the funding agreement. Now, we have seen in practice a few funding agreements come across our desk, and we've been in the process of sort of discussing some of those agreements. Do you have anything that you want to share about those funding agreements, any nuances of the funding agreements that individuals or parties seeking funding should be aware of, or how they should negotiate around?
Sure, Ashish. I think funding agreements are fairly detailed. It involves a lot of discussions. I think for the purposes of our session, I'll broadly touch upon 4 or 5 nuances, which are important clauses in that document. I think the first question which a lot of people ask us is what will be the involvement of the funder after obtaining the funding during the arbitration process. So I think the role of the funder is clearly set out in the document. And in most cases, we see that while the funders expect to be sufficiently notified of all the advices which are given by the lawyers, they actively do not monitor the arbitration. It's at the end of the day, it is the client's case, and it is for them to pursue in the manner in which they want to. But from the funder's perspective, they would want to be kept in the loop as to what is happening. So that is something which gets captured. Second most important aspect would be settlement of disputes. Obviously, this ties back to my first point, which I made. Often we see that a case which is funded, there are settlements in the process, maybe after grant of an interim order or before the trial or post-trial. So there is a detailed mechanism prescribed in the agreement as to what happens and what is the amount, what is the minimum threshold which one has to pay for an effective settlement. And the agreement also prescribes what if there's a deadlock between the party who has obtained the funding and the funder. And there are various mechanisms prescribed. It could be a joint opinion by an independent expert, so on and so forth. Parties could negotiate. There are a wide range of options. So it can't be, we can't typically talk of 1 or 2, but that deadlock mechanism is something which is usually prescribed in a very detailed manner. Then I think the other important clause is funders' entitlements. And Tom briefly touched on it as to the commercials of it. I think from a funder's perspective, what they look at is the cost of funding plus if any adverse cost had to be paid during the course of the proceedings. So that comes as the first threshold. Over and above that, there are typical calculations which are prescribed in an agreement. And that would depend on the time and the value of money which a funder has put in that litigation and arbitration. It could be a percentage of the total sum which has been obtained in a settlement or as in by way of an arbitral award, or it could be a proportion, maybe 2 times or 2.5 times of the cost that has been deployed by the fund. These are various arrangements, and it is at the negotiating table, and the parties decide on it. And as I told you, as I explained earlier, this is typically linked with the time value of the money. So if the amount is say 10% for 6 or 7 months from the date on which the funding has been provided, that amount may go up to 15, 20, 25% over several years. So that is the flexibility. That is how the mechanism is prescribed in a funding agreement. Now, there are also clauses on warranties. Basically, it prescribes how a party is supposed to conduct their case in the most diligent manner, and the funders should be made aware of all the developments, all the advices which the lawyers are providing, or all the steps which are being taken in the arbitral proceeding. Then there's also a termination clause. This is also very important. It sets out under what circumstances a funding agreement can be terminated, and as on the termination date, what would be the obligation of the funder. And this is again a commercial consideration which between the party seeking the funding and the funder. But typically what we see is that as on the date of the termination date, the cost which has been incurred up to that date is typically taken care of by the funder. So these are the few clauses which I thought would be more appropriate, more important. There are, of course, different schedules, different definitions in the funding arrangement, and it all depends on the case-to-case basis, the sector in which the funding is sought, the recovery of the money. It also depends on jurisdiction. For example, if a funder is funding a case in the United Kingdom, more often than not, you don't need to even file an enforcement proceedings. You get an award and the money is paid. So the funding arrangement will be slightly different than maybe a situation in India, where it takes about 1.5 to 2 years to enforce an arbitral award.
All right. So thank you, Alipak, for that. And I can see a lot of questions are being typed out on the chat window. Just to say that we will come back to all those questions, and you can continue typing in those questions. And after this, we'll try and take all of them one by one. So going back to the earlier discussion, and we have now heard from Alipak and Tom as to how this funding arrangement takes place. What are the nuances of a funding agreement? How does a funder look at a particular issue while analyzing whether a claim should be funded or not? But now, and this is where I want to bring Kishore in. And Kishore, we've been seeing Alipak and Tom explain all of this, but at the end of the day, this is something new in India, and we don't have any professional funders onshore in India, at least to my knowledge. Most of the professional funders, or all of the professional funders, are all situated overseas. So whilst we have this sort of a product which is there and available to the market, and funders are looking and exploring and providing and looking to provide this product to Indian parties, and at the same time, Indian parties are also seeking to avail this product. Are there any regulatory concerns that you foresee, and any work around those regulatory concerns in terms of providing this funding by a foreign funder to an Indian party?
Thanks, Ashish. Unlike other countries, India, as we all know, has exchange control regulations governed by the Foreign Exchange Management Act. Any foreign exchange inflow outflow, be it a current account transaction or a capital account transactions, is governed by the rules and regulations prescribed thereunder. Looking at the third-party transactions, it would have to be more in the nature of capital account transactions. And naturally, considering that RB has prescribed different rules and regulations, and that the third-party funding, as you said, is at its nascent stage here in India, let's look at some of the options that may be made available by a third-party funder. One, of course, is probably they can try and set up joint venture with the concerned Indian company, which is looking for the funds. While, of course, I would say that this joint venture would be kept at a minimal as far as the capital is concerned. The foreign party can put in further funds by way of external commercial borrowings as well. I will come to this external commercial borrowing part later on. The advantage in this, of course, is that the third-party funder would have management and control on this entity. But at the same time, being an equity shareholder, there are certain challenges also in terms of that it has to follow the Indian laws, such as the Companies Act, the Foreign Exchange Management Act, the tax laws. And subsequently, of course, the other challenge would be to upstream the gains as and when they get these monies out of the success that the Indian party would have. The second option the third-party funder can probably try is a subsidiary in India, which can be registered as an NBFC, a loan company with the Reserve Bank of India. Of course, while it can receive ECB external commercial borrowing from the third-party funder directly into India, again, the same challenges it would face as that of the joint venture partner. Plus, the NBFC again would have to seek a license from Reserve Bank of India, and the RBI guidelines are very strict as far as NBFCs are concerned. The third option, the third-party funder can probably try would be to set up an entity outside India and register it as a foreign venture capital investor, FVCI. This registration needs to be obtained from SEBI. FVCI basically is a subset of foreign direct investment. One of the advantages is that here they don't have to set up any entity into India. Second is, unlike foreign direct investment, for an FVCI investment, there are no pricing norms that are applicable. So as far as the entry of the third-party funder into India is concerned and exit, they can do it with the mutual consent of both the parties. Here again, but of course, the entity has to be registered with SEBI as an FVCI and hence it will be governed by SEBI. The other disadvantage for an FVCI is that it can invest only into 10 sectors prescribed by the Reserve Bank of India. So to that extent, this is a bit disadvantageous for a third-party funder. Similar to FVCI, they can probably look at setting up an entity outside India and registering as a foreign portfolio investor FPI, because FPIs are allowed to invest into NCDs of Indian companies, being debt instruments. Here again, they will have to seek registration from SEBI, and they would encounter the same challenges in respect of what the FVCI would face. Plus, the RBI has prescribed certain limits in terms of investments in the debt instruments. One more option that the third-party funder can look at is an external commercial borrowing. This is more a loan in foreign exchange that they would provide to the Indian companies. Here, they don't have to set up any entity into India. And the ECB guidelines of the Reserve Bank of India allow them to provide the ECB to the Indian companies for general corporate purposes. And the funding for the litigation would be one of the general corporate purposes. Since they can give this ECB, even an NBFC also now can obtain an ECB from a foreign entity. Here again, the challenges that a foreign party would face would be the restrictions that are imposed by RBI in the ECB guidelines, and importantly being the minimum average maturity clause, because if a funding has to be done through ECB for the general corporate purposes, there is a minimum of 7 years or 10 years minimum average maturity. Plus, there is a limit on all-in cost also. So to that extent, they would be restricted in terms of taking the gains out of India. The last, of course, option that the foreign party would have is to set up a pooling vehicle in India and register that as an alternative investment fund, AIF. Under the SEBI AIF guidelines, they allow a debt fund to be registered as category 2 AIF, which can seek funding from the foreign investors, and then it can be invested into India. Of course, they will have to set up the whole AIF structure in terms of having its own manager and a sponsor. The manager and sponsor can either be foreign owned or it can be even Indian owned also. This of course has to be registered with SEBI, though they would be guided by the SEBI guidelines. So in view of these options, considering the expectations of this third-party funder, and as Tom has said, one of the things they would expect is this purchasing or monetizing the awards, the security to be created on assets and the recovery of the same from the Indian parties, the returns that they would expect from the Indian parties. Then I believe the enforcement of warranties and other obligations on the Indian parties. I think we need to be very careful as to which option that has to be taken depending on what is the size of the funding that we are looking at, what is the Indian entity, what sector Indian entity is entered into, what are the different costs that they are looking at. So these are some of the options that probably they can explore.
Sure. Thank you, KJ, for that overview on from a regulatory perspective. Now, I have more questions for Tom and Alipak and Kishore on this, but I see there are a lot of questions which have now come up. So probably going ahead with that part, I'll just take some of these questions, and then if time permitting, we can go back to those additional questions that we have for Tom and Alipak for our discussion. So just going back, and I can see some of the questions which have just been posted to us panelists, which we can see. The first one is from Mr. Abhishek Gupta, which says, what if your client loses the arbitration proceeding? I think there's a straightforward answer to this, is something Tom said earlier as well, that third-party funding provided by these professional funders is non-recourse funding. And therefore, if a funded party loses the case, then there's typically no obligation which is left over towards the funders. After that, there is a set of questions from Chetan. Chetan has asked, and there are a number of questions which I'll go through. I'll go through them one by one. And is there any case law which distinguishes funding from wager agreement or success fee? Alipak, do you want to take a shot at this? Or otherwise, I can also try and address this question. All right, I'll just take this up for now. You will not, it's not unlikely to find a recent case law, but in the past, there have been number of judgments of various courts or various high courts across India where third-party funding arrangements have been held to be legal, and this tort of Champertine maintenance have not been held to apply to them. And in those cases, there's also a sort of a discussion around are these wagering agreements or not? And the courts have seen that whether somebody is pursuing a bona fide claim, and typically funders do their diligence before funding a claim. So it is not that this can be equated to a wagering scenario. And there are Indian cases as well which say and provide this. I'll just give an example. There's the Ram Kumar case, which is again a long back Calcutta High Court judgment, which is there. And there are several other judgments like these. The next question from Chetan is, assuming it's debt funding, what is the security and who are these funding agencies? Tom, Alipak, do you want to take a shot at this?
I can, to start with. It isn't necessarily debt funding. The typical model that we adopt around the world is actually an assignment model, where in consideration for the funding that we provide, we are assigned a share in the proceeds of the case. So if there are no proceeds, there's nothing to assign. If there are, then we are simply assigned that. So it's a proprietary interest in the proceeds of the case. Sometimes we register a security interest over that. If the jurisdiction allows us to, we will do that. But it is quite a unique form of financing in that respect. It doesn't fall neatly into a loan or debt arrangement. Equally, it's not equity. It is a category of its own. So it is quite different. And the non-recourse nature of it also has a different sort of balance sheet impact in most cases. There won't need to be a corresponding liability on the funded client's balance sheet for the funding that we're providing. So it is very unique. Who are these funding agencies? Omni Bridgeway is the name you need to remember. There are some others out there, but we should be the first on your list.
All right. Probably, Tom, are you going to say, the question is, what are the interest rates? But I guess it's not the interest rate, but typically I think there's another question around it, which is from Dinesh subsequently, which says, what is the general ticket size in such funding and what is the average rate of return on the funding which is offered? So if you could answer those two as well.
Sure. It's not an interest rate type model that we use. As I explained earlier, our returns are usually calculated as a multiple of our invested capital or a percentage of the recoveries. Ticket size, typically we don't look at cases that have a claim size of less than $10 million. We may look at awards that are less than that for enforcement, but if we've got to go through an arbitration process, Typically, we're looking at 10 million US and above. In terms of typical rates, as I say, it very much depends on the risk profile of the case. If you had a sort of medium risk case and we're funding everything, taking all of the risk, and you recover after, say, 3 years, then it wouldn't be unusual to be looking at a multiple of 3 times our invested capital or 30% of the recoveries, whichever is the higher. But that is not a rule of thumb. There is flexibility in that. It really depends on the risk that we're taking on and all of the different dynamics of the particular case.
Sure. So it's more like venture capital funding, where you look at sort of a multiple return in that sense on your investment, which is done.
Yes. Yeah, that's right. And it reflects the binary nature of the investment. If it's, as everybody knows, litigation, arbitration is not straightforward. Even the strongest cases sometimes lose. And if that's the case, then we lose our entire investment.
Tom, I think I'll bring you this again on this one, and I'll also ask Alipak to follow in after Tom, which is, are these funding agencies influenced by law firms? And I think there's another one by Mr. Dinesh subsequently, which is, can the outcome be rigged basis this funding? As someone was mentioning out-of-pocket expenses, that be the case, the whole thing could be essentially a fraud. Probably not sure where exactly Mr. Dinesh is going with that question, but probably it's connected to the earlier one. So Tom, any sort of relationship between law firm and funding agencies, what is that relationship, if any? And Alipak, if you could also sort of elaborate on that.
There are strong relationships between us and the lawyers that we work with on cases. It's necessarily that way because we are very much involved in our investments and wanting to ensure that they're successful. And so we get close to lawyers that we work with. We also get close to the clients that we're working with. If the suggestion is that we may be getting into arrangements with law firms so that they can charge whatever they want, and that ultimately comes out of the case, that the case proceeds, that's absolutely not the case. Our risk is tied up with the amount of capital we put into any investment, and the bulk of those costs will be legal costs. So we're very focused on managing legal costs and keeping those proportionate to what the case requires. And indeed, that's one of the aspects of our involvement that clients often seek, other than the financial support, is the experience we can bring to bear on cost control, on strategy, on what is necessary, what maybe isn't necessary, and we can actually take an informed view and keep a close eye on what's being incurred.
All right. The next question, which is there, is I think we've how big is the market in India? What type of arbitrations are covered? What growth are we seeing in this market? I think the question thereafter is also connected. How big is the global market? Which is the active market for such funding? Again, I think, Tom, you're best placed to answer this.
There's no easy way to measure the size of the market in India or globally. We do try from time to time to do that, obviously, to make business plans and report to our investors and so on. But it's a very difficult thing to estimate. I would say we see real potential in the Indian market and real growth potential in the Indian market. India is probably the leading source of applications for our Asia business. We tend to see applications at least once a week, if not more frequently, coming out of India. And that relates primarily to foreign-seated arbitration of Indian parties with disputes against foreign investors, or perhaps they've been involved in an offshore project that's gone wrong. It is also increasingly involving applications related to domestic arbitration and arbitral awards, people seeking to monetize those, and indeed portfolios of those. The other active sector is in the insolvency and distressed situations in India. We're hearing from promoters, from insolvency professionals that want to try and leverage the value in claims and awards. So there's a lot of potential in India. As Kishore mentioned, for foreign investors, there are also some complications to investing in the local market, but we see sufficient growth potential to try and navigate those complications, and that we are actively seeking to do. So growth potential for sure in India.
Alipak, I know there was a question addressed to you previously over there, and I move forward. But I think there are a lot of questions coming in, and I would need your assistance on the next two for sure. And if we have time permitting, probably we can circle back to that one earlier to you. So the next one there is for Kishore, and it is Kishore. Probably this is to your to a discussion that you did earlier, which is how do you view this from if it is a capital account transaction, then to what asset are such funding happening? How can functional expenses like payments to various parties be allowed from an income tax perspective? What assets are we creating out of it? So I know there are no correct or right or wrong answers because there's something very new, but at least it will be nice to hear some perspective around it or some issues or how it could be viewed in one way or the other.
Sure. More from practical perspective, and I think as explained by Tom, how generally this third-party funding happens. And most of the time, the funding actually happens directly to the different parties involved, like the lawyers' fees and all. And as far as India is concerned, as I explained, considering that there are these exchange control regulations, naturally, the flow that generally happens in the world won't happen here in India. And hence, to that extent, while I explained the different options, it was more for the third-party funder as to what are the different routes that are available as prescribed under the non-debt investment instrument rules, or the debt instruments, like either you set up as FPI or FPCI, or you set up an AIF in India or an NBFC in India, or that you lend the parties directly by an external commercial borrowing. So these are these are all capital account transactions. And most of the time, this flow would happen to the Indian company, unless, of course, we dig deep through this and try to find out different ways as to if the expenses can be directly paid to some of the parties, of course, within the four corners of law. But at least as of now, some of the ways that the third-party funder can do is to fund the Indian party, unless they set up an Indian entity, and through an Indian entity within India, they try to find out different ways.
Sure. Thank you. I think there are two questions now from Aditya. One is related to obligation to disclose the source of funding in case a party is funded, and the other is, can a mere existence of third-party funding be ground for ordering security for legal costs? Now, Alipak, I would like you to sort of respond to these. And I know that both these questions are a session in themselves. So probably you could just like throw some light around larger issues which are probably involved in this sort of consideration.
Now, as regards disclosure of funding in an arbitration, I think there's a lot of academic articles and people have been writing on this for the last 4 or 5 years. I think broadly, people are trying to reach a consensus that yes, it should be disclosed. Recently, in 2017, cCep investment arbitration rules categorically mandated that in cases of funding, it has to be disclosed before the tribunal. But in many cases, I mean, people don't disclose unless the institutional rule strictly provides for the same. So yes, while people are discussing and there's an increasing consensus, I don't see, other than maybe cCep, I don't see many institutions including that as part of their rules. Now, as regards to the second question on third-party funding being a ground for ordering security for costs, that the answer is no. Security for legal costs is awarded on the basis on which the cases are fought, on legal principles, on the application that you move, the determination by the tribunal. Third-party funding, to my mind, it will not have any role in the manner in which the tribunal would rule on such an application. One additional point, although not connected to these two queries, that goes back to the earlier cases which we were discussing. I think the most recent case which one needs to keep in their mind is the judgment of Supreme Court in AK Banerjee, where the Supreme Court expressly recognized third-party funding while holding that while a lawyer cannot fund their own case, but there is no difficulty absolutely in seeking third-party funding. I just thought I'll quickly mention that, since that is a 2018 Supreme Court case.
Sure. Thank you. The next question which we have over here, and I think there's one more below, which is on a similar line. At what stage does funding agreement can come in? And from the lens of assignment of claims under contract, what happens when respondent initiates counterclaims? Tom, Alipak, if anybody wants to give a shot on this, otherwise I can probably also try and see if anything could be added there.
I can comment very quickly. I mean, we see applications at any stage of proceedings. We prefer to be involved as early as possible because we can help shape the direction in which the proceedings go and help develop the case theory and ensure that we're monitoring assets for enforcement and so on. But we're often approached to fund appeals, to fund enforcement, or just partway through proceedings as fee fatigue sets in, or as companies want to free up some cash. So it doesn't really matter at what point we come in. The counterclaim question, a lot of our cases do involve counterclaims. We just need to reach a view that the net outcome will be in favour of the party that we're funding. So that they're going to either defeat the counterclaim, or if the counterclaim is upheld, their claims will offset that and result in a net cash flow to them. So that's how we deal with that. We don't insure against the counterclaim. Typically, if that's the question, that liability would remain with the client. But we do provide an indemnity in relation to adverse costs. So if they lose, we would pay the adverse costs and protect their downside in that respect. Just one more comment, which goes back to the last question on disclosure. And you know, there's obviously rules around when you must disclose, or when you probably should disclose. I would say most of our funded clients, that's the first thing they want to do. Because they want to be able to say to the other side, and indeed to their tribunal, that they've had a third party look at this case, vet it, and agree with them that it's a strong enough case to invest in. So more often than not, we are being asked to disclose, and we don't have an issue with that.
Sure. That's actually quite interesting from a commercial, that funded party itself it could be in the interest of the funded party itself to do that disclosure, or at least that's how they are viewing it as well. The next question is from Anurag. Sorry, we just covered that. I just wanted to add one point to this last question from Anurag Rajagopalan. When they speak about, from the lens of assignment of claims under contract, what happens when respondent initiates counterclaims? Now, when Tom earlier spoke of assignment of claims, and I'm just going to expand on that from an Indian law perspective. Even when there is assignment of claim in context that Tom spoke earlier, I think the funder does not pursue the claim. It is the litigant who still continues to be the claimant and pursues the claim in its own capacity during that process before the court or the arbitration. Moreover, under Indian law, the Transfer of Property Act under Section 6 prohibits anyone from assigning their right to sue. So a contract which has been breached, a claim under such contract cannot be assigned. However, under Section 131 of the Transfer of Property Act, an actionable claim can be assigned. And a right to sue is not an actionable claim, but a claim for a liquidated debt becomes an actionable claim. So if your claim is for damages, Supreme Court has held that a claim for damages is not an actionable claim. So only when your damages convert into an arbitration award, and then it could be said to be, it could possibly contemplate to be an actionable claim and can be assigned. So an assignment of claim is essentially will be viewed as assignment, or rather it should be assignment not of the claim, but of the proceeds of that claim. And that's how everyone views it. So it's not that the claim is being assigned, but it's the proceeds of the claim which are being assigned. The next question over here is from Prakhar Biani, and says, And I'm just realizing that we have 5 minutes left, so we'll try and go through these questions a little quickly and see how many we can go through. Is there a possibility of mitigating losses under non-recourse funding by obtaining insurance on the same? Is such coverage possible from Indian perspective? Will it be workable from a margin perspective, considering returns are needed to be fair and reasonable in order to not go against public policy? If I'm understanding the questions correctly, the first one, and I think there's a similar one below, is that can somebody get insurance, or can a funder get insurance in case it to protect its losses in case the claim does not succeed? And the second one could be, what is the margin or what is the return that funder needs to work with, or could be a margin there so that it doesn't go against public policy? Tom, if you would like to take these 2 points or to address these 2 aspects.
I think I can address the first one. I'm not sure if I can address the second, but we do use insurance products to help mitigate our risk. For example, our funds where we deploy capital from are all covered by an insurance wrapper that relates to adverse costs. So if a case that we are funding loses and we're required to pay out adverse costs, that risk is insured on a sort of back-to-back basis. We also sometimes take out insurance on specific cases if we're making a very substantial investment. Say if we're buying an award in the hundreds of millions of dollars and we're making a significant investment in purchasing that, we may insure some of our risk in seeking to recover that. Those insurance products, there isn't a huge market for them. There are a few providers and they come in at a significant cost. So we only use them when we absolutely have to, but it does exist, and it is a way that we manage our risk to some extent. I'm not sure I can comment on the margin perspective and public policy. Maybe
if Alipak has any comments there, or KJ, otherwise I'll sort of step in and try and see what best I can do with that. All right. So I think, yeah, go ahead, Alipak.
Sorry, I think the argument of public policy kicks in when something like this is per se not permitted. I think when the Supreme Court has clarified in 2018, I don't think it will lead to any public policy argument. I can understand there are some previous case laws in 1950s and 60s where in those facts and circumstances, 50 to 60% of the total proceeds were taken. Those were struck by public policy. But given the current commercial arrangements which we are talking of, I don't think public policy argument will fly in.
Yeah, no, I completely second that, Alipak, and I was also going to add to the same that earlier there were a few cases which said extortionate transactions could be held, could be set aside, but basically those were in context of back in the 30s or 40s, where some landlords using their position were typically taking the entire farmer land out of the farmer's possession under the garb of funding certain litigation. But now that the industry is so sophisticated, they have certain terms, they work under certain parameters. It is not a situation where a funding could be understood to be public against public policy. And as Tom was saying earlier, they typically don't fund less than a $10 million ticket size for this very reason, because they still want to ensure that a bulk of the claim goes towards the litigant and is not used to pay up the funder in itself. And therefore, that is something which is taken into consideration into the commercial metrics of a funding arrangement as well. The next question is from Kunal. What happens if the client loses the case? So I'm guessing what happens if the funded party loses the case? Does the funder have the right to file an appeal? Or in that sense, I can expand on it, or to cause the funded party to file an appeal? A quick answers, a yes or no from anyone around on our panel.
Yes. Yes, that will be built into the funding agreement. Yes, and we would exercise that right if there were good chances of success, and that would be presumably in the interests of the funder and the client. But if the appeal was unlikely to succeed, we would be unlikely to exercise that right.
All right. And the last one, and probably we'll close. We have at 6:30, and we said the session would be for 1 hour only. So I'll just take one last question and close it after that. I know we have more questions after it, but sorry, we'll be running out of time there. Alipak, if you want to take this, what would be happy if deadlock mechanism is further explained? So if you could explain the deadlock mechanism in the funding agreement.
One option which comes to my mind is if there's a deadlock, the party who is seeking funding as well as the funder, they can both individually reach out to independent experts and get a view on the position of law which they are trying to argue. If the deadlock still persists, then the parties can jointly come together and appoint an independent expert, and that can be binding on both the parties. I think this is the easiest way to do it. But there is no set rule. There could be mediation, there could be various things which can be tried, but the idea is to have a third party look at this point and then basically have a binding nature on the recommendations provided by the third party.
Sure. All right. I think we have more questions and probably we can answer them by way of mail or otherwise. But I'm sorry to other people. We have run out of time here. And I'd probably like to thank our panelists once again. Tom for joining us today, Alipak, KJ, Kishore. I think this has been very interesting. The number of questions that we have received, in fact, shows the interest that this area has and how quickly this field is growing in India. And I think there are plans for funders, and I think Tom and others are also looking at India very closely. And Omri Bridgeway is also looking at in India closely to see if they can be and to sort of consider this market as one of the key markets globally. With that, I'll again sort of thank all our panelists and end the session here. And I'll hand it back to Mamta to sort of close the session.
Thank you, Ashish, Alipak, Kishore, and Tom for a very insightful and educative discussion today. Our next session will be held today at 6 p.m. IST on keeping the corporate wheels churning during COVID-19, hits and misses of the corporate compliances, followed by a session at 9 p.m. IST on M&A case studies. What are the legal and tax issues in brand acquisition deals? Stay tuned for interesting sessions every day. You can register on our website or through LinkedIn. Thank you everyone for joining us, and you may now disconnect your line.